All right, today we're diving into a really fascinating legal puzzle called hearsay. You've probably heard the term, but at its core, it's all about evidence that comes from something said outside the courtroom. And that brings up a huge question.
I mean, think about it. This sounds like something straight out of a movie, right? What happens when your single most important piece of evidence, the smoking gun, comes from someone who can't be put on the stand to testify? This isn't just a fun hypothetical, it's a real challenge that courts wrestle with all the time. So to really get our heads around this, let's follow a case. Picture this. A pretty straightforward business deal goes south. The one employee who wrote down all the details of the agreement has unfortunately passed away, and their notes, they're sitting on an old computer in the office. So the big question is, can those digital notes actually be used in court? Let's find out. Okay, so where do we even begin? Before we can argue about what the notes say, we first have to prove what that computer file is in the eyes of the law. This is kind of the first gate we have to get through. The law says that a statement like this might be admissible if it was made as part of an undertaking. So, what on earth does that mean for our computer file?
Well, as you can see, the legal definition here is incredibly broad. We're not just talking about big corporations. This covers public service, professions, trades, you name it. Whether it's for profit or not, it doesn't matter. So because of that, our employees' notes from their job, yeah, they almost definitely fall under this big umbrella.
And if you thought undertaking was a wide net, check out the definition of a document. It's even wider. Of course, it includes the obvious stuff like books and photos, but, and this is crucial for our case, it also includes any disk, tape, or, I love this legal phrasing, any other record of information, whatever. So that old file on that hard drive? You bet. The law sees it as a document. Okay, progress. Our file is officially a document from an undertaking. That's step one. But the whole reason this is so tricky is because the person who wrote it isn't here. So how does the law deal with that?
Well, the law is actually very specific about when a witness is considered unavailable. For us, it's pretty straightforward. The employee is deceased, which is number one on the list. But look at the other reasons. Someone could be medically unfit, they could be impossible to find, or it could just be way too expensive or time-consuming to get them into court.
And you have to love the history here. That phrase, beyond the seas, sounds like something from an old pirate map, because it basically is. One judge actually used this quote from Shakespeare to explain that, look, it's an old term that just means someone is outside the court's jurisdiction. It's a great example of how these ancient phrases still echo in our modern legal system.
All right, so our evidence has made it through two gates. It's a business document, and the person who made it is legally unavailable. But now we come to the hardest, most subjective hurdle of them all. Can we actually trust it?
This is where the court has to become a bit of a mind reader. It has to look at the person who wrote the notes and ask, were they a person interested? In other words, did they have any reason to lie? Any skin in the game that might have made them twist the truth, even just a little? And what's really interesting is how the thinking on this has changed over time. The old school test on the left was super strict. You basically had to have zero personal stake in the matter. But the more modern view, on the right, is way more realistic. It's not about being perfectly neutral. It's about looking for a real, substantial reason for that person to distort the truth. So let's bring that back to our case. The court would have to dig into the employee's situation. Was their job on the line? Was their reputation at stake? Were they trying to cover for a mistake or maybe make themselves look better? If the answer is yes to any of that, if there was anything that could have reasonably affected their impartiality, that evidence could be thrown right out. Okay, so let's imagine our document makes it past all three gates. It's a business record, the witness is unavailable, and the court is satisfied the employee wasn't biased. That's it, right? Case closed? Well, not quite. You see, getting evidence admitted into court is really only half the job. It just means the judge or jury is now allowed to see it. It does not mean they have to believe it. Now, the real work begins. They have to decide how much weight or importance to give those notes. So, how do they figure that out? Well, the law gives them some things to look for. Timing is a huge one. Was the note written right after the meeting, when everything was fresh in the employee's mind, or was it weeks later? They also circle back to that bias question. And of course, a really basic one. Did the employee actually know what they were talking about? And this is the final safety net, and it's so important. Even if a statement technically checks all the boxes, a judge still has the power to exclude it. If the evidence is just too technical for a jury to understand, Or if letting it in just seems fundamentally unfair, the judge can say, no. It's a way to make sure that following the rules doesn't lead to an unjust outcome. When you step back and look at this whole process, from defining what a document is to weighing the words of someone who's gone, you're left with this fundamental challenge. The law is in a constant balancing act between the need to hear all the evidence and that difficult, relentless search for the truth. It really makes you wonder, doesn't it? Without being able to look someone in the eye and cross-examine them, can we ever be 100% certain?